Our next case is Witten versus Witten. Talk about 15 minutes for that argument. Counsel, how long would you like to reserve for rebuttal?
5 minutes, Your Honor.
Very good. 5 minutes to be noted. I'll be keeping time up here. I'll try to let each of you know when you're down to about a minute left in your time. The arguments are being recorded, so when you come to the podium, please introduce yourself first. Please make sure you speak in a clear, loud voice so the recording can pick that up. And please stay behind the podium, because if you move around, the video will lose you at that point in time. I don't know that in this case we have any concern about victims or children, but if you were to have any concern like that, please use a name like victim or child or initials if you would. The court is ready to be briefed and ready to proceed whenever you are.
Thank you. Good morning. My name is Attorney David Berta, and I represent the appellant in this matter, Barbara Witten, who was the defendant in the lower matter. This is a matter that was a long-term marriage that at some point in time they entered into an agreed entry for divorce, which included the provisions on spousal support. The real crux of the argument really is whether spousal support in this matter automatically terminated it or not. You could argue that there are two different provisions within the decree that actually may, in fact, not mean the same thing. One of which, obviously, was the standard of death of either party, permanent retirement, or disability, or cohabitation. There's also another provision that says spousal support shall end at some point when the appellant or appellee, in this case, were to collect his retirement benefits. In this case, the question that really I believe is a statutory, not statutory interpretation, but the interpretation of the parties and the meeting of the mind of the parties in relationship to whether spousal support was intended to actually cease upon that event or whether or not one party had to file a motion to terminate it. Since, in fact, the court did reserve jurisdiction, and it is in the colloquy on the record, which is on page 7 of my brief, that indicates that either party can file motions to extend or decrease the spousal support or limit it. Because it was a long-term marriage, I believe the court was correct in maintaining jurisdiction of that. And in this matter, I would give you that there was never a motion filed, so there should not have been a termination of that support. Had, in fact, appellee filed that motion, it would have been set for hearing, and then the court could have determined whether or not that support should cease. But I don't believe there was an automatic triggering event that caused that motion or that support to stop in and of itself.
Did your client eventually file a motion to modify support below?
She did, along with the motion to
Show cause.
contempt, to show cause, and then also...
So she filed both of those at the same time?
Correct.
And there was a hearing before the matter scheduled. Was that an evidentiary hearing, or was that just an oral argument type hearing?
There was a hearing for the magistrate. There was not an evidentiary hearing on that. We submitted it on the briefs, which we did in fact do. So the argument was, I understand the magistrate says, well, I don't find support appropriate. He did in fact say that based upon the briefs. My other argument, which I think is more important in this regard, other than it was appropriate, is whether that automatically triggered the ceasing of the payment of spousal support over time, number one. And number two, whether or not the amount that was held in escrow by the pension trust account until the qualified domestic relations order was submitted was in fact my client's or the appellee's. The fact is that $33,000, if you read the brief, was held in escrow until 18 months, then released back to him. The QDRO, I believe, came about a month after that.
So basically, it was given back to him in part by the company because 18 months expired.
That's correct. Correct. If that would have been in time, she would have gotten it. Perhaps he would have been in court arguing that's my money.
I think the record indicates that he paid money to your client all during that time when that wasn't occurring.
Correct. It was
so
exact.
Was there anything ever from the company saying, oh, now we know he paid his money to her, so we're going to give the money back to him, or it just simply, as far as we can tell from anything from the company, it just expired, the 18 months expired, so the money went down?
Correct. That is my understanding, that after 18 months, according to the law and the ERISA Act and the things due to federal requirements, that money would go back to the policy holder, the person who's retired, the beneficiary in that. However, I would indicate that gives credence to the idea that he kept paying support throughout that, the same amount he was paying before, which was the $2,300, if I'm not incorrect, and do forgive me if I am. It was brought that amount of money. So he kept paying that amount, and then when he did receive his retirement, he stopped paying it, and she started receiving her amount, which was $1,800 a month, which was different. And obviously, the argument on the other side may go, well, he was actually paying her more, so she shouldn't complain. But I believe if you look at the record, I don't think there was a meeting of minds whatsoever. These two people, I believe, thought differently about what that spousal support provision meant. And I think if you read the record entirely, as well as the decree, if there's a conflict, there may need to be testimony. And I did indicate that to the court. However, she made them make a statement, to let them make a statement, which was not sworn testimony. And after reviewing the facts and records, including the colloquy, because quite frankly, I didn't first remember that aspect, never thought to get that. It's still part of the record. So I did receive that and get that. And I did notice that the court did say, you understand there's a reservation of jurisdiction, neither party can file to terminate.
And you're referring to the divorce hearing back in 18 or so, whenever that occurred?
Correct, absolutely.
Was
When it was
that,
before the court.
that transcript of that hearing, was it before the court on the objection?
It was not. It was only part of the record because it was part of the court proceedings. But that was something that I had not, quite frankly, remembered as to what transpired there until my client had indicated that's what happened. I said, well, I better go back and look at that because obviously that's very relevant. So,
And remind me, was this a case where your client showed up at the day of a trial or some pre-trial and read an agreement under the record, then that agreement was typed up after the fact? Or was this all typed up before?
you know, it was not typed up before. That I know, and I don't remember if it was typed up that day or after the fact, meaning.
So the separation agreement would have been prepared after the hearing?
Yes, it was contemporaneously with, or meaning that day itself, and we read it on the record, and then submitted it that day. But it definitely was not prior to going in. It was a contested trial day. We spent the day negotiating a settlement to that.
And your client had an opportunity, of course, to review the separation agreement, sign it?
She did review it, exactly, and it was the provisions that are in there. Certainly, we don't doubt that they are. I believe there's a conflict in those provisions. I think a cleaner document, to be honest with you, and that goes to the effect of perhaps drafting, whether it be the attorneys or otherwise, might have been to not have those two separate provisions in there and have them all in one of what terminates spousal. Because there's two provisions. There's your typical, and then there's later on, as to whether or not you can interpret that as an automatic termination of spousal or the reason to terminate spousal. So if it was automatic, it would obviously automatically take place. If it was not automatic, and that's what I'm arguing, that it was not automatic, it would continue until someone filed a motion. And obviously, my client wasn't going to file a motion because she was the benefit of that. So I think at some point in time, based upon those circumstances, that she should in fact have gotten that $33,000, which is held as part of her property distribution for 18 months. And then, and I did file for that at the court too, to get that back, which they denied. And then the $2,300 was to continue, and I put in my brief, even to this date, until there's a motion filed, or perhaps stay during the Court of Appeals if the court would so determine that. Interesting issue. Obviously, it's a statutory interpretation issue, not clear cut per se, and I think that's the reason why, if at the minimum, it might need to be remanded for a hearing to see what the parties intended, whether or not one party said, no, this was always my understanding, and whether the other party said, no, that wasn't my understanding at all. Court speaks through its entries, and I think in this situation, the court spoke two ways. Perhaps that's the argument. I know the other side will probably say it's pretty clear. However, I don't think it's clear at all, and I think the triggering mechanism is not clearly delineated.
And let me ask you then, before you sum up, get the record question, make sure I understand. So at the magistrate's hearing in this case, after you filed the motion for show cause and the motion to modify?
Yes.
Was there ever a hearing where there's an argument for the magistrate, or the magistrate just said, you folks submit your briefs and whatever else you want to submit, and I'll make a decision?
That's exactly what happened. Submit your briefs, whatever else you want to make argument regarding, and I'll submit the decision. That was done, and then obviously it was objected to the judge. And then the judge had a short oral hearing on that, but no evidentiary testimony, sworn testimony under oath regarding what the intents of the parties were at the time the agreement was ever made.
And then on appeal, I think the trial court decided your motion to modify support and deny that.
That's true.
I don't read your brief as appealing that decision. Is that fair?
I'm not appealing that decision whatsoever. At this point in time, I do believe you're correct on that. It's a matter of statute. I shouldn't say statutory. That's not what I meant. It's a matter of how you read the document.
Understood, it's kind of inconsistent with your other arguments, so you're not arguing that. I get that, I just want to make sure I was correct in saying.
No, you're absolutely correct. I wouldn't argue that both ways. Just,
You have about a minute left in your time.
I'm done for right now. Thank you very much.
Thank you. You'll have your full rebuttal time.
Good morning. My name is Brent English. I am counsel for Thomas Witten. I want to begin by pointing out a number of inconsistencies, I believe errors, that have just been stated by opposing counsel to the court, and to clarify a misunderstanding that I believe Judge Stevenson has based upon the record. So here is what happened historically. In December, particularly December 28th of 2018, the parties were divorced. In fact, the judgment entry was prepared in advance of that day. There are a couple of handwritten interlineations in the entry that would reflect that the entry was obviously prepared before we showed up here, or at least prepared while we were here. I represent to you that it was not prepared while we were here, but in fact, it had been prepared some time before. The relevant section is section 6 of the judgment entry that deals with spousal support. I don't think there is one confusing aspect of this entry. What it says is that husband, my client, shall pay to wife as in for spousal support $2,300 per month directly to her before the 15th of each month, and shall continue until husband receives his pension. That's what it said. So, while Mr. Berta would like to contend that this is ambiguous and that we aren't really sure what this means, I don't know how much clearer it could be. Shall continue until husband receives his pension. So when did he receive his pension? After the divorce case, in fact 4 months after the divorce case, in April of 2019, my client applied to the Teamsters Union, who was the entity that held his pension, for his pension. And in May of 2020, so that would be 13 months later, he began to receive his pension. At that point, spousal support had to terminate, and in fact did terminate. He receives his pension. He did not have to file a motion to have this happen. This was a self-effectuating proposition. But he was stuck with the following problem. We did not yet have an approved qualified domestic relations order that applied to that pension, even though it had been submitted for whatever reason, and I could explain to you the difficulties with this, but the pension administrator for the Teamsters was, let's just say, less than cooperative. So ultimately, we had the trial judge, Judge Swensky, approve a pension that was drafted by, not a pension, a qualified domestic relations order that was prepared by a non-party pension group, a well-known entity that assists lawyers in preparing appropriate qualified domestic relations orders. That occurred in September of that year, and then it took the pension administrator 17 months. This is the issue that Judge you mentioned. It took them 17 months to ultimately approve, and it was approved in early December, which was in the 17th month of the 18th month window that they had. Now, during that time, my client could have elected to not pay any more spousal support. He could have elected to do nothing and simply let the money sit there in an escrow account until that pension was ultimately approved, in which event Mrs. Witten would have got whatever was held up in an escrow account beginning in May of 2020. However, he regarded, and let no good deed go unpunished, he regarded that it may not be fair to his wife to not receive any money for that 17-month period. So he elected to continue to pay $2,300 a month in spousal support while the money was ultimately worked out with the pension. After December, starting in January of 2021, Mrs. Witten began to receive her portion of the pension. Regrettably, Mr. Berta is incorrect. It's not $1,800 a month. The record shows unequivocally it's $2,119 a month that she received for her portion, the coverage portion of his pension. At that point, unequivocally, he had no more duty to pay spousal support. In fact, he didn't have a duty to pay spousal support since May, but he agreed to pay it to her directly, not involving the court. I'll pay you $2,300 a month until you actually start to get your pension. And when she started to get her pension, he ceased and let no good deed go unpunished. She then filed a motion to show cause why he should be held in contempt for not continuing to pay spousal support, even though he had voluntarily paid 17 extra months of spousal support at $2,300 a month. And she claims all along that somehow he had to file a motion in order for the spousal support to terminate because he misreads the order that says it shall continue until husband receives his pension.
The order, you're referring to the separation agreement when you say the order, is that correct? The
The
final decree
separation
itself,
agreement that's incorporated in
the final decree doesn't have specific language about this, it's all just in the separation agreement. That's the only place for us to look as far as.
Correct.
Yeah.
It's incorporated within.
Right, understood.
Okay.
Now,
So-
at least I understand his argument to be, yes, that first paragraph of spousal support seems fairly clear in that it says it will terminate upon the retirement or specifically shall continue to allow to receive his pension. He said that's clear, but then you go on to say, here are the two bases in which it will terminate: death of either party or remarriage or cohabitation. Those two things, he says, are inconsistent. If you had simply said C, and upon the retirement of husband, we would say, okay, that clearly wasn't going to terminate. It terminated according to the agreement. He said, because to me, those things aren't the same, it's not consistent, and we have inconsistency in the document, and how do we deal with that?
Well, I don't think they're inconsistent, and let me tell you why. In the event that, let's assume for a moment it happened exactly as I told you. In December, the parties are divorced. He has an obligation to pay support, spousal support, until such time as he receives his pension. That's what it says. The next day, Mrs. Witten goes out and gets married. That would ordinarily be, in fact, under the statute, it is a disqualifying condition with respect to spousal support, unless you otherwise provide for it in the judgment entry. Or let's assume she passes away. Not promoting that, but let's assume she passes away. If by his theory, my client would have to pay spousal support, presumably to her estate, even though that is not the law, up until the time that he received his pension. These are not inconsistent provisions. So those two provisions, which are customary, typical in every divorce decree, would apply here entirely. Further, let's assume that she hit the lottery and she's now working with $10 million of free money. I would think Mr. Witten might file, prior to the time when he receives his pension, a motion to modify or terminate spousal support in as much as the financial circumstances are radically different. Now, these circumstances did not occur, but they well could have. which is exactly why this is in the judgment entry, to provide for every possibility that would relate to spousal support. Now, I want to focus on the second issue that Mr. Burdick.
Before we do that, I want to make sure that you're on the same page about what occurred procedurally after the motions were filed.
I am not.
With the mayor. Was there an evidentiary hearing on this motion before the mayor?
Most certainly there was. It was done via Zoom. Both parties were able to testify. There is no record in front of you as to what was said. After that, the magistrate said if you have anything further to add, you can do so by way of affidavit, which Mr. Witten took advantage of and Mrs. Witten did not.
Do you recall the date of that hearing?
Sometime in March
Of what year?
of 2023.
Is there any order on the record that details that a hearing took place or anything like that from the magistrate? Or is there any way for us to determine what you're saying is correct and there was some evidence taken at some point in time?
There is a judgment entry. I do not want to misstate what it says, so I would refer the court.
Thank you. The magistrate judgment entry would, you think, if anything, had to be in there explaining what was going on?
Correct, and you will see that there was an affidavit submitted by my client and no affidavit submitted by Mrs. Witten prior to the magistrate making his decision in this case.
Do you recall by any chance if there was an order from the magistrate detailing at least the procedure explaining after the magistrate's hearing, I'm giving each party X amount of time to file a brief after our oral hearing? Do you recall if anything like that?
Yes, there is.
Okay. And that may explain also, or may show there was a evidentiary hearing that took place.
Correct,
Okay.
but it is the duty of the appellant, in this case, to produce the record, and for whatever reason, this was.
When I just wanted to determine was there or not a record, he was indicating to me there really was no hearing in front of the magistrate. We went and said we're going to submit all this on briefs, and that was what was done. So be it. That's one question, as opposed to what you're telling me. There was in fact an evidentiary hearing. Witnesses were called, they testified, and
Correct.
Subject to examination, I presume, and that's what happened. But it happened on Zoom. Is what you're telling me.
Correct, it happened on Zoom.
But
Definitely
I
was not
think-
in person.
Please continue on to the second point.
Okay, with respect to the second claim that he's made, that somehow Mrs. Witten should receive the amount of money that was held in escrow, let me point out that the reason the money was held in escrow was because the pension administrator had not yet approved the qualified domestic relations order. So it was approximately $2,119 and change per month that was held in escrow, which would have gone to Barbara Witten had the qualified domestic relations order been approved. However, during that entire time, Tom Witten paid $2,300, which was more than that amount, to her, even though he didn't have to. So he did this as an accommodation to her, as I've mentioned, while the money sat in escrow. As soon as the qualified domestic relations order was approved, the Teamsters refunded to my client the amount of money that it was holding in escrow for the benefit of Mrs. Witten, because she had already received $3,400 more than she would have received if the money had been held in escrow.
Is there communication from the Teamsters in the record as to
Yes,
what they were
there is.
doing?
Yes, there is.
Thank you.
Okay.
And you're
So-
down about a minute left in your time, just so you know, Counsel.
Right, I appreciate that. So, based upon what I have told you, and I think I've tried to brief this matter carefully so that you can see exactly what has transpired, I respectfully submit that the appellant's assignments of error are not what they give, and that the judgment of the trial court should be affirmed. Thank you.
Thank you.
Good morning again. I will indicate that if you do look at the separation agreement, page 7, number 6, it indicates, as this court has already indicated, that the jurisdiction and amount of duration spousal support, which shall terminate upon the happening and following events. A, death of either party. B, appellee's remarriage. I think that should have been appellants at this point, that might be a mistake. Or cohabitation with an unrelated non-family member, and that is in the separation agreement. The provision that Mr. English indicates says that shall continue until husband receives his pension. Doesn't say shall terminate. It just says that amount shall continue until he receives his pension. So I think there is a distinction there. Furthermore, there was not an oral hearing sworn under oath, and if you look at the magistrate's decision of this August 25th, it says the matter came for consideration upon defendant's motion to show cause and to continue spousal support. Attorney Brent English represented plaintiff, attorney Dave Berta represented defendant. Upon consideration of the briefs of the parties, the court follows and finds. There was not an evidentiary oral hearing. I remember distinctly speaking with the magistrate, do you want a hearing or do you want it on the briefs of the affidavit? Now, my client did swear under oath that my brief was accurate and true. So whether you want to make a distinction of, well, you should have put it in a certain format because she didn't say that everything you said was true. Well, she said, I've read the brief, it's true, she swore under oath, and that was in relationship to that. The pension, not that it's a big distinction, but there's a letter attached to my brief. It was $1,800 and some dollars a month they were withholding, not $2,100. So the fact is, it did not automatically terminate. If it did, it would have said shall terminate. It shall continue, doesn't mean shall terminate. And there is already a provision of termination. Why would you have a separate provision on shall continue?
Counsel, what if it said, husband shall pay $2,300 a month for 24 months? Would the argument be the same? Would you still need a termination hearing?
No,
in
you
month
wouldn't, because it
25?
gives a definite date certain when it would terminate, 24 months, expiration of.
So it's the fact that it's not a date certain, it's a occurrence.
It just indicates that shall continue until he receives his pension. Then there's some other language obviously on there that says shall terminate. And the real question is apparently from what I'm hearing is, and I have no reason to doubt this effectively, is my client thought that meant something different than Mr. English's client. And which one was correct? And they rely upon signing that document based upon that? I don't know. Certainly we haven't had the oral argument. I know what my client would say. She's going to say, I thought that was continuing until we had full hearings on that. So, in this point, he never filed a motion to terminate. So I would ask that that provision either be, my argument be upheld in the sense that she be granted money that was withheld from the pension trust, and also the amount of money during a duration, at least until the appeal was filed, or that it be remanded to determine that issue. Thank you.
Thank you. The court will take the matter under advisement and issue a decision in due course. When that decision is released, the clerk will mail a copy to you and also to the Supreme Court website. And I'd like to thank both of you for your presentations today on behalf of the court.
Thank you very much.